Perhaps one of the most difficult and emotional parts of a divorce is the topic of who the children live with, commonly referred to individuals as the custody of the children. So there are many different factors that go into deciding who gets the children in separation. So tell me, Diane, what are the ways that people can make a decision about the care of their child or children?
Look, many separated couples are able to reach an agreement about the future care arrangements for their children themselves without going to the court and sometimes without seeing a lawyer. Why this is, they know what their children do. They know what they do on a Monday, they know what they do on a Wednesday, they know what they do on a Friday. Court should always, of course, be a last resort if people are unable to get an agreement with reference to the time that they are to each spend with the children. But agreements can be reached through a host of processes. That is, they can attend mediation, they can go to those mediations with organisations. There's Relationships Australia, the Family Relationship Centre. They can also reach agreements through the collaborative process. And also, they can reach an agreement themselves after they separate to decide what is best for their children on the basis of what they know about their children. These are their children. They know what their children need. There may be special needs involved for their kids. It's really important that people consider their children when they are looking at who they should live with and their arrangements as well.
Because it often becomes, I'm a child of divorce, and it is often that whole porn thing, but it's changed a lot since the 80s. It used to be Dad just saw us every second weekend, and it's a lot more 50-50 now, which I think is great because dads are getting to spend as much time with their children as the mothers, but it is about what's best for the children.
Absolutely, and when people consider what's best for the children, they know what's best for them because they know what they're doing.
Rather than a lawyer or the court.
Absolutely. We may not know that on Wednesday afternoons they have soccer, dancing and all these things that one parent may be able to take them to, but the other cannot, so they can assist on that day. They will be able to reach those agreements. They know how to, they know what their children are doing, absolutely. So obviously the best way is for them both to reach an agreement. That's always not.
That's the best case scenario,
Absolutely.
But it's not possible a lot of the time.
It's not always possible. And unfortunately, separation is an emotional time for everyone. And it means that some people may not make decisions that are right. And so if parties cannot reach an agreement, of course, a person's only option is to then make an application to the court. As I said though, courts should always be a last resort. But if people do get an agreement, they can do it two ways. They can do a parenting plan, which is essentially a plan that sets out what's going to happen in relation to their children by their agreement. What's important is though that plan is what we call not binding. It's not a binding document. For parties to get a binding document, if they do get an agreement about their children, they should get consent orders, which essentially is a court term for an order that's made by agreement between the both of them.
Yeah, such as officialising.
Absolutely, the agreement that they have.
Okay, love it. So how is it then, if you do go to court, how is it decided who gets the children then?
A really good question, and one that I can answer in some respects in 1 minute, but I won't be able to give the answer that I could give in an hour. The reality is the court's paramount consideration, and people do use this term often, is the child's best interest. The court will always, when looking at making an order about a child, they will look at what is in that child or children's best interests. When the court looks at what's in a child's best interest, there's then a number of factors that they look at. And the two primary factors are the benefit of a child having a meaningful relationship with both of their parents, but also protecting the child from harm. So the court will look at those two factors as the primary factors, and then they look at a host of other things. The nature of the children's relationship or child's relationship with the parent, any views that may be expressed by the child. But in saying that, when we look at views, we've got to look at also the maturity and age, and there's other circumstances looked at within those factors. So there's a number of factors the court looks at when observing whether an arrangement will be in the child's best interests.
The best thing you can do if you face this situation is to stay calm and understand the process. And if you need any advice on this topic, or you're looking for an excellent lawyer to assist you through the separation, give the team at Ruhl Family Law Centre a call today.